Hi, everybody. My name is Olivia Romanson, and I am your presiding judge for this year. And today we're going to be going over directs and crosses. Now, whether this is your first year or your fourth, I'm going to be going over a really just broad range of topics to help cover all of my bases and to help you guys perform the best you can at state conference. So, without further ado, I'm going to share my screen. Okay, awesome. So, questioning. So, first things first, whether you're going to be in the Jefferson Davis building or the Capitol, all your courtrooms are going to flow the exact same. When you get there, your judge is going to go over pretrial matters, like asking permission for water on the desk, technology, stuff of that kind of sort. And then after, the judge will ask if the prosecution is ready to give their opening statement. The prosecution will go, then the defense will go, and then the prosecution's time is to present their evidence. So now you're going to call up your three witnesses. And for, say, your first witness was Leslie Moore. And you're going to direct examination Leslie, and then the defense is going to cross-examine. And then after, the prosecution is given the opportunity to redirect their witness. And if they take this opportunity, the defense is then given the chance to recross. But after one redirect and one recross, the court moves on to the second witness. This goes on until the prosecution has called three witnesses to the stand. And then it is time for the defense to present their witness. And it's the exact same process, except the defense is now on the direct examination and the prosecution is on the cross. Once they've gone through their witnesses, you'll present closing statements with prosecution going first. And the prosecution can always save up to 2 minutes for rebuttal, which will be given after the defense closing statement. And after that rebuttal, the trial is over, and the judge will then take some time and present a verdict. So, how exactly are we going to go about direct examination? So, after opening statements, the judge is going to ask, will the prosecution please present their first witness? And after they do that, the attorney who is going to be direct examining their witness will stand up and say, Your Honor, the prosecution calls Chris Riggs to the stand. The attorney will then ask that witness questions based on their witness statement. So your goal is basically to prove an element of case through this witness testimony. What exactly are you trying to prove? When you're writing these questions, write that question on the top of the witness statement and come up with an answer for it. For example, with less more, you're trying to prove that the business was failing financially to help show motivation for Willie Freeman to kill Devin Frost. Because you're trying to prove those elements of your charges through your direct examination. And make your witness believable. Ask them this series of events to really get to your big bang moment. Basically, meaning walk the court through the process of events through that witness's perspective that leads you to the conclusion that you need to prove motivation, to prove that Willie had the means. Stuff like that is gonna help you get your verdict. And big thing on direct examination, you cannot have leading questions or questions that have the answer in the question. So basically, if I were to ask, did you see someone there? That's not a leading question because it's a yes or no. What is a leading question right off the bat is, isn't it true that you isn't it true that Devin Frost had a gambling addiction? Stuff like that. Or like, isn't it true? Would you say it's correct that Lou Contrallo is a little shady? Like stuff like that, it's like the answer's already in the question. It either ends in like correct, starts with isn't it true? Those are leading questions. So this is what is on your rubric that your evaluators are getting to score you off of your direct examination. So excellent direct examinations will only use relevant facts and will not go on a wild goose chase, meaning you're really using your time effectively to prove stuff that actually matters. Don't go on this random link that you're trying to prove, but it doesn't really work. Like, look exactly what's in your witness statement and highlight those facts that you want your witness to say for the court to hear. Leading questions are not to be used. That's a big thing. Good attorneys will know and actively object to any questions that are not allowed. So you are being scored on how well you can object, and as well that you are being scored on how often you get objected to and that they're right. You know what I mean? Like if you're up there and a big thing when it comes to objections is learning how to pivot. So say you accidentally had a leading question in your questioning, or and somebody objects to it and it gets sustained. So now you as an attorney have to either rephrase your question or move on. The best attorneys are going to know how to pivot and change their line of questioning. So instead of asking, and isn't it true that you saw Willie in the alley? You should say, what did you see in the alley on that night? So by making it into an open-ended question after getting objected to, can help boost your scores and prove to the evaluator that you understand how to adapt to a changing courtroom. And you're also being scored on your cooperation with witnesses, level of preparedness, and strategy to prove your case. So with cooperation of witnesses, they're just looking for that you are being cordial and polite to your witnesses and not cutting them off. Level of preparedness has to do with, did you write your questions during that trial? Do you have an idea where you're going with this? And strategy to prove your case is hand in hand with the idea of not going on this wild goose chase kind of thing. So, what are some example questions for a direct examination? So, always start with the question, what is your name? Just to introduce to the court who they are, what's their occupation, and really just those foundational questions. How are you related to this case? So the court can understand, oh, okay, this is what this person is doing. I can understand the context of what they're about to talk to, and stuff like that. You could go into where were you on the night of questioning, asking those questions to get to your conclusion. What did you witness about the behavior of the defendant? That can be really good if you have a witness that is like a character witness or best friends with the defendant, has known them for a while. Trying to prove that they aren't such an angry person and would never kill someone, stuff like that. Did you see the defendant leave? What did you see on the victim's face? All of these questions have to do with pretty much your five senses when you're thinking about a direct. Because with your direct examination, most of your witnesses are what we consider lay witnesses. And these witnesses can only testify to what is observable to anybody. So a lot of it is like, what did you see? What did you notice? What did you hear? And like very easable questions that anybody can answer, and not very like specific, like they can't testify to the mental health of the defendant because how would they understandably and like observe somebody's mental health? You can say, what did you notice about the behavior? And they can notice that they were alone, they were crying a lot, they were having like distancing themselves from their friends, but you cannot ask to what was the mental state of the defendant and the witness answer with depression. Does it make sense? Um, so yeah, so questions are about observable things. You can't really speculate about anything. Again, no leading questions. This is a really big point that we have to bring up in direct. And one of the cool things that you can also do in direct and cross, but I'm just going to cover it in direct, is this is where it's mostly done, is you can enter in a witness as an expert witness. So this is going to be really important when you have a witness that has a lot of knowledge on a subject. It helps get you points with the evaluator and kind of just opens the door for how much you can question about this witness. But there are a few steps you have to do before you do that. So first, you have to establish either knowledge, training, education, skills, or experience. So these are the prongs of what you need to be an expert witness. And you only need to prove one, okay? As it says the word or. And the way that you do that is asking foundational questions. Where did you go to school? What jobs have you held previously? What experience do you have with in the medical field? What awards have you gained? And stuff like that, proving that they have the knowledge, the training, education, experience. And once you feel that you have done this, you're going to say to the judge, the prosecution or defense, it's up to you. The prosecution now moves to enter John B as an expert in whatever field that you believe is applicable to that witness. So it needs to be a specific field. Like it can't just be the medical field, pretty much. And you can always get that from where they like kind of majored in school and like what their experience is based on. A lot of it can be like it's like very specific when looking at like police investigation, or you could look at like there's like some autopsy reports, stuff like that. Expert witnesses can testify to pretty much anything in their field, and their ability to answer questions gets wider. Because once they have been entered, you're able to ask them about their expert opinion on things within their field, and what they say is taken on a higher credibility within the court. But on the flip side of this, if if you believe that your opposing counsel has not established one of those prongs to be an expert witness, after the opposing counsel asks permissions by the judge is going to ask if there's any objections. And at that point, you are totally within the right to stand up and object and say, Your Honor, the opposing counsel has not proved the proper foundation for this witness to be an expert. Maybe you object to the specific field because you don't believe that that field um, is what that witness truly has experience in. Or you just object to the point that not enough has been established for us to believe that this witness is an expert. And once that happens, the judge will make the decision. And if that objection is sustained and your witness was not entered in as an expert at that time, please go back and ask some more foundational questions. Go back through what knowledge do you have in whatever field? What experience have you had in whatever field? And you just re-ask those foundational questions and then try again for that witness to be an expert. Because hopefully by that point, enough has been established for the judge for them to let it through. Basically, what I'm saying is don't just give up if the objection is sustained the first time, because it most likely will not be sustained the second. All right. So for witnesses during direct examination, you are a huge part. Direct examination is your time to shine. Basically, be your character. This is your time to truly show those acting skills that I know all of you guys have. And a big thing, memorize your witness statement and memorize the answers to the direct questions that your attorney is going to be asking you, because those answers are usually pre-written. And once you are able to memorize and understand what the attorney wants out of you, you're gonna find that witness attorney chemistry where you're able just to have a easygoing conversation in court, which is gonna help both your evaluation scores as well as the attorneys. Okay, perfect. So that covers our direct examination part. I'm going to put examples at the end of this video, but now we are going to switch over to the flip side of direct examination, cross. Cross is a lot of people's favorite times, but we also just need to understand how exactly we're going to get that across and to make sure that every single point that we want is heard. So you're questioning the other side's witnesses. You are now what I like to say the bad guy to this witness. You're trying to discredit them, prove weaknesses, so show contradictions, making this witness look uncredible and to hurt some of the points that were brought up with indirect. So, and as I said, with direct examination, what element do I need to prove? You can ask yourself, what element do I need to disprove? So, with, for example, Chris Riggs, maybe you're trying to prove that he didn't actually do his investigation as well as the prosecution wants you to believe. You're trying to prove that he is unreliable, a little sketchy, and you can do that through poking holes in his witness statement. So, unlike direct examination, leading questions are encouraged because leading questions is the best way to make sure what you want is heard because the attorneys should control this narrative. You're going to want to trap your witnesses. Yes or no is the way to go, is what I always say. Because why are you allowing the opposing counsel's witnesses time to defend themselves when you are trying to prove something that they're not necessarily gonna like? So by asking those, isn't it true? Isn't that correct? Kind of style of questions, is you're going to hold that witness's hand to the conclusion you want. So again, this is a rubric that is given to your evaluators. Well-prepared witnesses or well-prepared attorneys will control the witnesses to fit the narrative they are trying to prove and will have prepared, thought-out questions that will undercut the opposing counsel's case. So again, with the fact that you are trying to not just restate what was said in direct with the background, but you are trying to be like, okay, you said that you saw Willie hold a knife in his hand. But isn't it true that you were across the alleyway? But isn't it also true that it was dark outside? So trying to prove those hints of doubt in what the opposing counsel has said. Leading questions are allowed and are encouraged. Something that will separate a good attorney from a great one is their ability to stay calm when something unexpected or surprising happens. Cooperation with the witness is also scored. So, what it means by staying calm is you and your witness are on opposing teams. So, sometimes that witness may say something that really does throw you off. Or instead of just asking in the typical or answering, like, yes, yes, no, no, they begin to defend themselves a little bit more. And I've seen it before that some attorneys get flustered when that happens. But if you are able to stay calm, listen to what that witness is saying, and then be like, okay, but when you look at it and just kind of just flip everything that they just said, and it's still pushing for your narrative, that is how you are going to be a great attorney. So, some example questions. Didn't you have a past relationship with the victim? With those type of questions, you're trying to prove maybe some bias, that they're not as unbiased as the court wants them to be. You even said you like him. Isn't that true? You have paid for his expenses for a year, correct? Did you see him leave? You and the defendant had a rivalry, correct? Sorry. And basically questions like that, you're trying to prove some bias. Maybe they aren't being as truthful or they're not as good as the prosecution or the opposing counsel wants you to believe. You've testified in court today that X happened, yet you never actually tested for this. This can be a really big one when looking at experts when they say that, or police officers, if you're trying to prove that maybe they didn't test for everything in their investigation, and when they assume something, it doesn't mean it's necessarily correct, which is a good thing to exploit when on cross-examination. All right, so witnesses in cross. This is one of the hardest points to be a witness before. I remember when I once was a witness and being crossed, I was really scared the whole time. But what really helped me is to really just stand up for myself. And that is what I want all y'all's witnesses to do. So don't be afraid to say your side of the story. Stick to your guns, you know? If they're trying to make you look like an idiot on cross-examination, don't just sit there and take that, you know? Just be like, no, that's not what happened. This is what happened. And really, just stand up for yourself. Now, as I say this, if the judge asks you to answer in yes or no, please listen to your judge. Because sometimes um an attorney, a good attorney, went on cross-examination, has a witness that is rambling on for a really long time after every question. They will first ask the witness nicely to answer in a yes or no fashion. And when that happens as a witness, you should comply. I mean, you're trying to have some good cooperation with your attorney. You don't want to come off as um, mean or just kind of in any of that sense. But if there's a question that comes along that you really do believe that you can defend yourself on, you can go ahead and do that. Um, but if the judge then asks you to answer yes or no, I would just listen to the judge. The judge's ruling is the like last final say in a courtroom, pretty much. All right. So another thing that you can do on both direct and cross is enter in evidence. Now, we all seem to have a little bit of trouble with the process of this, so I'm just going to go over it super fast. So whether you're on direct or cross examination, it's totally up to you. Just make sure you have enough time. So first thing, step one, is you're going to ask the judge for permission. Basically, you're going to stop your line of questioning and turn to the judge and say, Your Honor, I would now like to approach the bench to retrieve whatever exhibit number you like, but for this example, we're just going to do exhibit one. Exhibit one for the purposes of identification. And then after you've approached the bench, grab the exhibit, you can ask, Your Honor, may I approach the witness to hand them exhibit one? That's how you can split it up. You can also just ask the judge in one big swoop, Your Honor, can I approach the bench to retrieve exhibit one and then approach the witness to hand them exhibit one for the purposes of identification? Really is up to you. It's not like a set way. You just need to ask permission before approaching the bench as well as the witness. Step two, ask establishing questions on the exhibit. Must prove identification and relevance. So the reason that the must prove is in all caps is because before a judge can enter in an exhibit, they must you must have proved identification as well as relevance to the case. So what is it I just handed you? Has it been damaged in any way you last saw it? Is it a true and accurate representation? Foundational questions like that are going to help you get those identification and relevance points and as well prevent you from being objected. Basically, when it is still an exhibit, you cannot ask the witness to read from it or to ask any like non-foundational questions. You must wait for that exhibit to be entered for you to ask those types of questions. So step three, ask the judge for it to be entered. Your Honor, at this time, the prosecution moves to enter exhibit one as prosecution evidence one. So when you have done that, it is now within the judge's hands, and the judge is going to ask if there are any objections the opposing counsel would like to raise. And if there are no objections, then the exhibit will be entered for the court. And usually, if you're wondering, well, what can you object to in an exhibit? You can object if identification and relevance was improved, and just kind of stuff like that, that there wasn't enough foundation before this exhibit has been entered, or you can also object to like its contents and stuff like that. It really goes on a case by case basis. Step 5, once you have entered the exhibit, it is now considered evidence, and you can ask questions about the contents of the document. Like you can ask your witness to read certain lines from it, or to display the content of it, and ask like, what did this lead you to believe, and stuff like that, and like move into a more further line of questioning to prove a specific point with evidence. When you are done questioning about the document, like you proved all there is you needed to prove, you're then going to ask the judge if you can approach the witness and to retrieve evidence 1 and return it to the bench. It is really important to enter in evidence, as it does help you get some points with your evaluators, and it also just really does boost your case. And sometimes you can bring back up the evidence within closing statements or maybe with other witnesses to help establish a true point. Like if you wanted to bring up a certain piece of evidence with one witness and then bring it back up in a cross of another, and then back up in a direct of another witness to really prove how this piece of evidence solidifies your entire case, that would be a pretty good strategic point. All right. So the last thing I wanted to also cover is steps for impeachment. So if during cross-examination your witness does not answer your question correctly, meaning that it's blatantly against their witness statement, but if they answered it in a way that you didn't want, that's not considered impeachment, but it's only if they are contradicting their witness statement. You may go through the steps of impeachment. So you can impeach on cross or direct. It's totally up to you. It's most common on cross-examination because on direct, that witness is on your team. So you want to try to help them get the right answer instead of impeaching them right away, because impeachment leads to the discredit of that witness. But maybe you have a strategy of discrediting that witness helps your case. Totally up to you. I've just seen it more on cross-examination. So, step 1, you're going to ask, are you sure? After the witness has answered incorrectly, it is common practice to either re-ask the question or ask the witness if they are sure of their answer. This is basically just common courtesy, really just trying to make sure it wasn't like misspeak or misspeak. Like if they said something wrong by accident, it's just really just to be polite. And then you can ask the witness once they've answered, like, yeah, I'm sure. Ask if they remember giving a sworn affidavit before testifying in court today. Then you're going to ask the judge to approach the witness with their witness statement. Basically, you're going to say, Your Honor, may I approach the witness and opposing counsel with a copy of their witness statement for the purpose of refreshing the witness's memory. So the reason it says opposing counsel is you're getting the witness statement from your own resources. The judge doesn't necessarily have that. They do have binders with witness statements in them, but a lot of the times teams provide their own just in case. So basically, when you get it from your bench after the judge says yes, you walk over to opposing counsel and you go like this, just to prove that your witness statement that you hand to the witness can have no markings on it, no highlights. It needs to be a clean copy, or else it's not going to be able to go through. So step 3 is you're going to ask the witness if they could read off specific lines from the testimony. You, as an attorney, should not be the one reading, as we're only here in court to listen to the testimony of a witness. You know what I mean? And all the witness statements are numbered for their lines. So you're just going to have to be like, can you please read line 32? And that would be the line that they directly contradicted in the original question. So once they've read that witness statement, you're going to then re-ask your original question to the witness. Because once you do that, their answer is going to be different. Or you can, I mean, you can re-ask the question. You can ask, do you want to go, like, you also testified to tell the truth and the whole truth in court today? Were you lying in your witness statement then, or are you lying now? Impeachment is really just there for discrediting. It's kind of up to you what you want to do, but that's the process of it. And then once you have proven that they were lying, is that you're going to ask the judge to return the witness statement to your bench and just continue with your line of questioning. So, the most important step, if you went through the time and the effort to impeach a witness, it is very, very important that you bring up your impeachments within your closing argument. And basically, you're telling the court that this witness is unreliable and we can't trust a single thing that came out of their mouth. That does sound dramatic, but it will help your side of the case if you are able to correctly impeach a witness. All right. So we're gonna go over some examples of directs and crosses that I have had from previous years. So this is just an example of a direct examination. So the red is what the witness said, and the black is the questions. So the red is what my witnesses would memorize in order to be prepared for our trials. So you see how we have our foundational questions of what is your name, what was your occupation, and Miss Doyle was our victim in the case. So that's when we started getting relationships with the victim, and John Diamond was the defendant. So this is a direct examination of the defendant. So basically, it's going through specifics of the case. How did you protect Trudy, which was Trudy Doyle, Miss Doyle? And that question specifically was to help disprove that John Diamond had any malicious intent to ever hurt Trudy. So a lot of it has to do with him having a close relationship with her. And this is what I used to do a lot when I was an attorney, is that if I was to ask a question that I wasn't totally sure on if it would get objected to or not, I would have the rule number that proved that my question was actually okay in court. So when I was given a rebuttal by the judge, I was prepared on what to say and to help get a lot of her decisions on my side. Asking specific questions of what happened on specific dates to help get a background for the court and to get my defendant's perspective. A lot of the questions of, see, we have another hearsay exception because there was a conversation, and just to prove that it wasn't hearsay. And you notice how I'm just at 27, so I had 29 questions in total here, proving that I decided that I had enough time to have 29 questions within our 20 minutes of direct. So with John Diamond, it doesn't look like I entered in any evidence, which is okay because a lot of his exhibits didn't really match with him, and I had other witnesses that did enter evidence with. So this is an example of a cross-examination. You notice how there is no answers because it's not my witness. They don't have to memorize that. And I about had 19 questions when it came to this cross. I'm not sure, this might have been somebody on my team as well. So basically, I established just really quick what's her occupation to really just set the scene of events. I don't need to necessarily ask her name again because it was already established within direct examination. So this was a very important question that within that case of the John Diamond case is that they tried to make it seem like that this witness that I was cross-examining knew everything, saw everything within the case. But I noticed in their witness statement that they turned their back to the area where the defendant and the victim happened, meaning she didn't see what happened within that vestibule, is what it was that year. So I tried to exploit that within my cross-examination of, after seeing this, did you turn your back on the vestibule? So you didn't see John Diamond walk to the vestibule. So when you say John Diamond pursued Trudy Doyle to the vestibule, you had no knowledge of this actually happening. That sounds a little sassy a little bit, but it was really just to prove that she did turn her back. And while she may say that this happened, when you really do look at the series of events, she didn't, you know? So that's what I mean with in the presentation of exploiting those weaknesses and contradictions, stuff like that. Um, and just proving that it was a regular occurrence and basically trying to disprove anything that she would have said within her direct examination within this cross. Um, basically proving, do you know what happened to cause her to do this? If you have a witness that is saying, um, this, that somebody else shook their head because they were scared. That was the context of this. I would, what I did in my cross-examination is I exploited that by saying you obviously don't know that she was scared because you weren't there, you know? So when looking at your witness statements, try to see those contradictions and see where the witness makes assumptions that helps, say, the prosecution. And in your cross-examination, prove that those are just assumptions and not facts. And really, when you look at the broader context of it, it's wrong. And it can help you when you come to your closing statement, wrap it all up and be like, while this witness says that she was scared, when asked about it during cross-examination, it was proven she wasn't there. She had no knowledge of the context, proving that she cannot definitively say that she was scared. It is trying to put that doubt on your judge's mind, especially when you are the defense, because you do not have the burden of proof, only the prosecution does. And so if you are able to put any amount of doubt onto the prosecution's case, is going to help you tremendously when it comes to that verdict. So these are both examples of a direct and a cross. If you want to um if you want to either reach out to me for more examples or send me any directs or cross examinations, I can definitely look at them. But that is going to conclude our video for today of questioning. If you have any questions, please feel free to reach out to me. I will send out my email again. But thank you guys so much for listening, and we will be back with more videos.